first on the principle of distinction, that is the prohibition to direct attack at civilians and at civilian objects, and as well the prohibition of indiscriminate attacks.
I will be talking about precautionary measures that armed actors should be taking and the constant care to reduce incidental harm to civilian objects, and discuss certain measures in actual fighting.
And I'll be talking about the impact of uncertainty in identifying military objectives, performing the proportionality calculation, and determining whether you need to take feasible precautions in attack.
I will have 4 parts. I will first have a short introduction, then discuss lawful targets for persons, so the distinction between combatants and civilians, then the same for objects, the distinction between military objective and civilian objects, and then finish with the notion of indiscriminate attacks. So in terms of introduction, my first reminder is that the rules on conduct of hostility, of course, they apply in armed conflict, but they apply only for hostilities. There are situations of use of force in armed conflict which are not governed by the rules on the conduct of hostility, and we might tend to forget that. So there are also situations where even the armed forces might have to use force not under the conduct of hostility, but under the law enforcement, the rules governing law enforcement operations. You have a few examples: maintaining law and order in occupied territory, crowd control, and in detention settings. Those rules are much stricter. I'm not going into debating when they apply, because you also have lots of debate on that, but just to avoid giving the impression that the rules on conduct of hostility govern all use of force by military in armed conflict. That's not the case. It only governs the rules of force when it is actually hostilities. Of course, the rules on the conduct of hostility are based on the main principle of IHL, so the principle of military necessity and humanity, and it's a balance between those 2 main principles, like any other rules of IHL. Rules on the conduct of hostility has to be looked at, whether they have been respected or not, based on the information available to the commander at the time of when he took the decision, when he was planning the operation, not ex post facto. That's certainly a difficulty when assessing real case example, because the information available to the outside observers is a lot reduced compared to in some way reduced, and maybe also different from what the commanders has. Reduced because it's maybe not known what was the objective of the commander at the time. It's not known what information he had. It's maybe increased because then things appear that the commanders didn't know that, for example, there were civilians at the place, but the commanders didn't know that. But if he didn't know that and didn't had information reasonably available to know that, then this has not to be taken into consideration when assessing whether the commander respected or not the law of armed conflict. And the standard is for a reasonable commander standard. That's a standard which has been created by actually criminal law rather than IHL, but that has been also adopted as being the relevant standard to look at how the rules on conduct of hostility must be applied. So distinction, the basic principle, all of it, it's the distinction between combatant and civilians and between military objective and civilian object, because attacks can be directed only against combatants and military objective and not against civilian and civilian objects. So going to the first question, combatants versus civilians. Who is a combatant? Who is a civilian? When can they be targeted? So a civilian is anyone who is not a member of the armed forces. For NIAC, more precisely, a civilian is anyone who is not a member of the state armed forces or of organized armed group. I will come back to that in more detail in a minute. But that brings up 2 questions. What is armed forces and what is being a member of, or membership in armed forces? 2 distinguished questions. I think it's important to clearly have that in mind, because sometimes they might be a bit confused. So I'm going to look first at what is armed forces and then how you determine membership into armed forces. Armed forces, it's all organized groups, units under a command responsible for a state parties to the conflict. that's the military, that can be police as well, or paramilitary forces when they are integrated into the armed forces, when they are incorporated through a formal act. That's rarely the case, but it's the case, for example, in Italy and in France. In Italy for the Carabinieri, in France with the gendarmerie. More and more often, in current armed conflicts, you also have police forces which are tasked by the government, officially or de facto, to take part in hostilities. That's not expressly foreseen in IHL rules, which only speaks of formal incorporation, but that's certainly, in our view, relevant in terms of targeting and protection, lawful targets and who becomes a lawful target. If a state tasks one of its police units to conduct a hostility on its behalf, it's a unit which is responsible to that state party for the conduct of hostility, and therefore they become lawful target. They become de facto, for targeting purposes, part of the armed forces. I'm leaving aside whether they can become POW, that's another discussion. But for targeting purposes, they become so. The difficulty is that when it's not done formally, is to identify which one, because usually it will not be like the entire police force. If you take a classic example, Afghanistan, you have a police force which is called the counter-terrorist police. Of course, the counter-terrorist police have been established on purpose to battle against the Taliban, the Islamic State of the Islamic Emirate of Afghanistan. So, of course, those ones, they are lawful target at all times, like the military. That's not the case for the traffic police. So we need to distinguish within the police force which department, which unit, which group have been formally or de facto tasked with doing that. It's sometimes not easy. You find places where you have a governmental decree which says all the police force have to support the military in the fight against the insurgency. So do we draw from that it means all police force, including the traffic police, would be lawful target for the conduct of hostility? No, we would really, that's why I say both, looking at what has been done formally, and in fact, when they in fact are tasked to do that, they become lawful target as a unit all the time, but not the traffic police, because even in the situation I have in mind, the traffic police is actually not doing conduct of hostility against the insurgents. Organized armed group are the armed force of a non-state party to the conflict, and it's important to distinguish that. I will come back in a minute. Terminology don't help us because we often speak of groups for both. We speak of groups to speak of the armed forces of the party to the conflict, and we speak of groups to speak of the party, the non-state armed group, the non-state party to the conflict. But actually that needs to be clearly distinguished. One is the force, even for non-state armed group, and one is the party to the conflict, the equivalent of the state, if you want, under IHL, which might have civilian function and administrative function, and I will come back to a minute. But terminology is not helpful here because we speak of groups for everything. So membership, you need to distinguish between regular force and irregular forces. For regular forces, regularly constituted forces, that's army and the police, when they are incorporated, even when they are de facto incorporated, but still membership in the police is defined under national law. So individual membership in a unit police, which is only de facto tasked to conduct a hostility, the individual membership is still regulated by domestic law. So that's how you need to define membership in armed forces. For irregular forces, that's a lot more complicated. Irregular forces can be both on state and non-state. There is a tendency to look only at the non-state armed group because that's usually only irregular forces, but you also have irregular forces on the state side. And to take two recent examples, that's the case, or that has been at least the case recently in Ukraine, where you have militias which fight on behalf of the state, and that has been the case in Iraq since quite some time, where you also have Shia militia fighting on behalf of the central government, so on the state side of the non-international conflict. And the discussion is the same in our view, both for irregular forces of the state or of the non-state armed group. And we view that as being the person who have a function for that party to the conflict that includes taking a direct part in hostilities, which we label continuous combat function. Continuous is for the function, it's not for combat. It's not somebody who needs to combat all the time, but that has a continuous function that include taking a direct part in hostilities. That's one of the contentious points that certainly Mike disagree with our reading, and other people as well. I think it's important to, they disagree because they find it's too restrictive. I think it's important to clearly distinguish two kinds of situations. One is when the armed forces are of the non-state armed group, to take that example, are clearly separated from the state and are clearly organized in a different manner. And I can think of People's Liberation Army during the non-international armed conflict in Nepal. So that was on the side of the Maoists against the royal army of the state. Or you have also other organized armed group, armed wing, which are very well organized. Let's take the Qassam Brigade in Gaza, thank you, when there is hostilities between Israel and, in the Gaza Strip. So for those kind of situations, I think we can discuss and cut hairs in fours, as you say in French, but the result of either approach is the same. The members of the People's Liberation Army in Nepal, I've met them in the countryside. They are marching in like a regular army. They have uniforms. All of them have a function which includes combat, like any member of the armed forces. So for those groups, I think the debate is a bit sterile, because the result is the same. The interesting part is when you don't have a clearly separated armed wing. And let's take the example of the Islamic State group in Iraq. The Islamic State group in Iraq, of course, they are fighting, but they also have administered territory, less and less because they are losing territory, but they have administered territory. So they also have people who have political roles, who have administrative roles, etc. So now you need for those groups to distinguish who is a member of the armed forces of that group and who is not a member. And you cannot just say it's a member of the Islamic State group, because you have plenty of members of the Islamic State group who have other functions. So how do you determine that somebody is a member of the armed forces of the Islamic State group when those armed forces are not properly separated? And that's why we developed the notion of the continuous combat function. So it's all persons who have, for the Islamic State group, a function that includes participating in hostilities. To take the debate one step further, one of the criticisms of the approach of the continuous combat function that has been raised is that we would make this balance between state armed forces and non-state armed group armed forces by having a more restrictive approach, because we have said that somebody who has the function to cook is not a continuous combat function if he has only the function to cook and not also fighting. And state and some critics have said that this is not treating them in the same way that we treat state armed forces. And I disagree with that, and I take the example of the cook. Of course, you have cook in the state armed forces, and those are lawful targets at all times. And now if you take the reality of current armed conflicts and you take an American based in Afghanistan or in Iraq, you have people who are private members of private companies who cook. Usually they are very often Filipino, actually. So that's why we refer to the Filipino cook. They often come from there in practice. And they cook on military bases. So they are on the base. They do the same task as the military cook. They obey the instruction of the military cook, who will probably be the head of the cooking section. And the difference is that if the base is ever attacked, the military cook, he will take his rifle and fight. And the cook who is contracted by a private company to cook, the Filipino cook, as I put it, he will hide under the table. And everybody agrees that the Filipino cook remains a civilian, despite the fact that he's on the base, he's paid by the military, he's doing cooking for the military all the time, but he remains a civilian. What's the difference? It's precisely that one is expected to fight and the other is not expected to fight. That's the same for the non-state armed group. Somebody who is expected to cook and to fight then has a continuous combat function in the way we understand. Somebody who is expected only to cook, he doesn't. Of course, combatants exclude members of the medical or religious personnel. So I will go very quickly about direct participation in hostilities. You know there are three criteria that was in your preliminary reading. So that's based on the interpretive guidance that we have suggested. That's the criteria we suggest. They are not in the law. In the law is only what I went too quickly through, that civilians are protected unless and such time as they take a direct part in hostility. But that's not defined. We have suggested that there needs to be three criteria, and to try to illustrate them, I have suggested a few examples here. The father who is throwing cocktail Molotov, he's directly participating in a family. It's a very strange family, but the mother working in a weapons factory is not directly participating in hostility because that's not causing directly harm, but the factory, of course, is a military objective, the weapons that are created, but that's another question. Being involved in propaganda, dissemination, or raising fund is not directly participating in hostilities. It's supporting the war effort, but it's not a direct part in hostility. Gathering and transmitting intelligence, it depends if it's done at the general level or for a specific operation. If it's for a specific operation, that's part of that operation. Like calling somebody to say there is an army vehicle going out, so you can target them in 2 minutes when they go down the road. Of course, that's part of the operation, and that's directly participating in hostility, but not if you just gather general information about the enemy. Sabotage, it is. Driving ammunition, it's the same. The same as transmitting intelligence information. If it's bringing ammunition to a frontline position which is engaged in combat, of course, that's part of that combat operation, but not if you move ammunition between warehouses. Now, again, the munition themselves, they are military objectives. And carrying a weapon as such is not sufficient. You have many people carrying weapons in Afghanistan or in Texas or in plenty of places. That's not make you a lawful target. Military objective. The definition is in Article 52 of the first additional protocol that agreed to be now the same definition under customary law for both international and non-international armed conflicts. And civilian objects are anything which is not a military objective. Two interesting debates. First is the question of dual-use object, an object which is used both for military and civilian purposes. So that's not a term which is used in IHL. Everybody agrees that if the military use is such that it fulfills the definition, then it becomes a military objective. The debate is, what do you do with the civilian use or the civilian function or the civilian part? And our view, and I believe that's the most widely accepted view, though not universally, is that the civilian use or function or part of that military objective has to be counted for proportionality and precaution analysis. Second debate is on the war-sustaining objects. That's a term which has been coined by the US, and they clearly have the position, the United States, that objects which are war-sustaining are part of the military objective, of the definition of military objective. In our view, of course, they may be a military objective. Fuel may be a military objective when it's fuel storage that is used, that is intended to be used to put fuel in the military vehicle of the enemy. That's a classical military objective. But the military objective requires a close nexus to the fighting, and the contribution to the war effort is insufficient. So what is understood as being war-sustaining as opposed to war-fighting or war-supporting is not per se sufficient to be a military objective in our view. As I said, the United States have a different view. Prohibition of indiscriminate attack, just a very few words. There are three kinds of indiscriminate attack, those which are not directed at a specific military objective, that can be with any weapon, and those which employs a means of combat which cannot be directed at a specific military objective or whose effects cannot be limited. And for the second and third category, that's from this that derives the prohibition of indiscriminate weapons by nature. But the prohibition of indiscriminate attack goes beyond the prohibition of indiscriminate weapons by nature. Those which are by nature, so could never be properly directed. The V2, to take an example, the V2 used by Germany against London, those cannot be built, they can never be used. But the prohibition of indiscriminate attack also prohibits using methods which in the circumstances of the use cannot be directed or whose effects cannot be limited, even if they could be used lawfully in other circumstances. One example, Scud missiles could be used in the deserts against a tank formation, but they cannot be used to attack a military objective in the middle of the city because they cannot be directed at a specific military objective in the circumstances of the use. Water and fire might be possibly used in some circumstances, but not in circumstances where they would escape the control of the user. That would make them fall under the third category of an indiscriminate attack.
I have a question inspired by Laurent's presentation. It concerns what you talked about, direct participation in hostilities. And you said that if civilians contribute to intelligence gathering by one party, that might or might not amount to direct participation in hostilities. And now what I wonder if a party to an armed conflict, say a state party, actively encourages civilians to gather information on the opponent, for example, by promising money in return or making it a game, for example, take photos and upload them to the app and then you gain points or something like that, or connect it to a promise to healthcare or humanitarian aid perhaps. And this actually puts civilians in harm's way in various ways. How would you look upon that situation from, for example, the angle of the duty to take constant care in military operations, Article 57, or the duty to ensure respect of IHL, Common Article 1? Me personally, I think that intuitively it feels wrong to kind of, with these active ways, making civilians a part of military operations, but I wanted to hear your opinion on it. Thank you.
Thank you for the questions. That raises also the question of precaution against the effects of attack, which have not that been discussed, because you have precautions in attack that are expressed very clearly. But you also have to take all feasible precaution with regard to civilians under your control to protect them against the effects of operation, and that's probably fall more under that. Now, whether that's directly participating or not in hostilities or not, in my view, depends. In our view, depends on whether the information can be used for a tactical operation, in which case it's yes, and therefore makes those civilians a lawful target while they are doing so. When it's only like general information on how the enemy operates, that builds your knowledge, but is not part of a tactical operation, in our view, that's not the case. We would certainly not encourage any party to the conflict to do so. Now, we also need to, and to link it to your precise question, I would put that under the constant care obligation, which is in the article for attacks, but which is actually broader, which is in all military operations. Now, we also have to realize that there are lots of things that governments and parties to the conflicts do which might put civilians in danger and which are accepted. For example, having civilians working in ammunition factory, an example I gave before, that's also put them in danger. That's something which is regularly done. So you also need to factor that, what is the practice, and also probably, depending on the circumstances, how much you put them in danger, depending on the type of information collected, where it takes place, how it takes place, and all of that. But we are certainly not encouraging it.
And now invite Sar to talk about the principle of precaution and in particular how we can minimize risk in populated areas. Thank you, Sar.
I think it's one of the most interesting and the most, I think, underutilized rule in the law of armed conflict or international humanitarian law. But the use of it in this application is, if it's done properly, it actually will enable armed actors to better adhere to the principle of proportionality, to adhere to ensure that they are adhering to distinction, and basically ensuring that the risk to civilians is reduced. So and I'm going to talk a little bit, just discuss some of the provisions, and then I'm going to apply it in practice based on what I have seen in my work in Afghanistan, Iraq, Syria, Yemen, as well as my engagement with various armed actors. I've written an article about some of these measures that were taken in Somalia and in Afghanistan. It's in your reading package. But again, I will draw in some examples that I have seen in its applications by some militaries. So the first one is, in the conduct of military operations, constant care shall be taken to spare the civilian population, civilians, and civilian objects. And I would argue that this basic constant care obligation has to extend to all aspects of military operational trainings, plannings, and mission execution. Soldiers are trained to fight. They are empowered to use the most sophisticated and most powerful weapons to neutralize the enemy, to neutralize the threat. So they're given a lot of power. But at the same time, we want to inculcate, and the law requires, the balancing act of military necessity with the principle of humanity and trying to reduce the impact of war on civilians. So what you want to try to build in a soldier, in an armed actor, is this ethos also of humanitarian and protection. And therefore, I think there's constant care in reminding soldiers and armed actors that you do have an obligation in every aspect of your fighting of taking constant care. Now, with respect to attacks, what are the precautions that can be taken? It says, do everything feasible to verify the objects are neither civilians nor civilian objects, and they are not subject to special protection, but are military objectives, and that you should take all feasible precautions in the choice of means and methods of attack with the view to avoiding, in any event, to minimizing incidental loss of civilian life, injury to civilians, and damage to objects. This basically means that a commander in the planning phase has to assess, where are civilians present, has to assess what is the terrain that one is fighting in. Is it an urban area, is it a rural area, at the night, during the day, where civilians are mainly congregated, especially if you're fighting in populated areas. Where are certain protected structures, water treatment facility, critical infrastructure that civilians rely on? Where are schools, where are hospitals, where are religious structures, where mainly predominantly residential areas. So it is as part of your planning phase, a commander has to get a really good understanding of where all the civilians are present, where all the civilian objects that one is required to try to protect and try to reduce harm to these protected entities. So it is an obligation that they have to constantly get information on, and in their planning, in their mapping of how they're going to be doing operations in a particular area. This also means that they have to when they decide what sort of weapons they use. I think this is a very important thing, that you have to ensure that your unit, is trained on how to use, is familiar with the weapons that they are being given. A lot of times, unfortunately, some armed actors have a lot of weapons that they don't know how to use properly. They don't know what the result of how these weapons are going to impact civilians, especially in a very crowded area. And so again, the obligation of the commander is to ensure that the means and methods of warfare, choosing an appropriate weapon system, the munitions, etc., should not cause disproportionate harm to civilians, because the language of Article 57 is about taking feasible precautions with the view to avoiding and the event to minimize incidental loss. Now, a lot of times, unfortunately, in this day and age, a lot of the battles that are being fought are in cities and urban areas, and so civilians are the ones that are impacted the most during the fight. You've seen it in the news. There's a lot of civilians are getting harmed or injured during battles. You've seen it where medical clinics, hospitals, water treatment facilities are damaged during conflict. And a lot of times, armed actors, unfortunately, are using munitions that will really cause a lot of harm to civilians, because some of these munitions, because they're indirect fire weapons, or for their large bombs, 1,000-pound bombs, for example, that when they land in a very crowded area, the perimeter of its impact and the blast fragmentation from these munitions is so wide that civilians and civilian objects are going to be impacted. One of the challenges is that so again, the commander has to ensure that the appropriate weapon system is being used for the area that you're engaging in, and that nowadays there's a lot of sophisticated technology that you can fuse, you can calibrate your weapon so that the blast fragmentation is reduced. However, there still are complications when some of these weapons are used in very densely populated areas, just because these weapons are just a little bit more problematic to use in these areas rather than in open battle spaces where there's less civilians present and when there's less civilian infrastructure. So again, this is the responsibility of the commander to make all of these assessments in the planning phase, ensure there's proper guidance given to his or her unit on and making a decision on the appropriate munitions use. I mean, one of the ways that in the planning phase that some militaries do, and yesterday in the evening, Professor Schmidt was talking about the US and NATO and some of the Western militaries have this very sophisticated collateral damage estimate methodology. And I don't know I think most of you were there yesterday, but it was a very interesting presentation. But again, it's a computer system. It's like all these metrics go in, and it allows a commander to foresee what the effects of these munitions will be, and then decide on civilians and civilian objects, and then deciding whether it's possible to use, or in the case of in the US, whether high command authority and approval is necessary to use this. I'm leaving aside the proportionality argument in this example, but I would sort of suggest that you don't need a very sophisticated computer systems to assess where munitions are going to land. I mean, I think it's great, but I think most countries, most militaries just don't have that. So I think when other countries are giving weapons to another country, or you are purchasing weapons, then you should know how to use these weapons properly, read the manual, and you should know where they're going to land. I've had so many conversations with armed actors and commanders, and they're using different types of mortars, rockets, or grenades, artillery, and when you ask them about, well, do you know how far it's going to land, and do you know? And I think there's like a lack of understanding of how these munitions are where they're going to land, and how it's going to impact civilians. So, but the commander does have an obligation to know and take the means and methods of warfare, and to ensure that they are not causing incidental harm and they're minimizing incidental loss to civilian lives. Another thing that is very important is that again, sometimes, during the planning phase, you have more time to assess, where civilians are present, see where the pattern of life is of civilians, where they're moving in and out. But, in the heat of the battle, when you see your enemy, or you see that the enemy is firing on your units, you want to protect your unit, and you want to engage with the enemy and neutralize that threat. So a lot of times, they're called dynamic strikes or targets of opportunity, where they're both is about neutralizing the threat but also protecting your unit that's under attack. It's where a lot of mistakes are made. We've seen this time and time and again, and we've been fortunate to actually, with some militaries, they do make some of their assessments on civilian harm public, so you're able to learn about what happened during calling in those kind of strikes. But you see in most incidents, most cases of civilian harm are during these dynamic strikes, these targets of opportunity, because there's less time to plan and think and know what's going on. But I would argue that there still are ways to try to minimize it. And we've seen that, for example, in Afghanistan, the U.S. military, the ISAF, the NATO forces, did try to reduce, even in those situations, in dynamic strikes, they try to take some measures to try to reduce civilian harm and question and to try to get a little bit more situational awareness, even in those dynamic strike cases. And one tactic that they used was, when forces are under attack, you can, try to take cover. Tactical patience, I love it. Try to take cover, protect your forces, and then wait for a while to see if you can get better situational assessment, understanding where the fire is coming from the other side, where the civilians are present, and then again, constant care obligation to make sure you're using the appropriate amount of force and response, or whether you think you can withdraw to seek cover and then find a better opportunity to engage with the enemy. So this falls into the argument of, refrain or cancel an attack. If you think that the calculus that commanders make, that if the military advantage is going to be excessive, the harm to civilians is going to be excessive to the military advantage, then you can cancel or suspend the attack. Again, the precautionary measures, taking feasible precautions at the time of the attack, you have to ensure that that the incident, the harm to civilians is being minimized. You have to constantly do this risk assessment in all phases. So the other way that one can learn how to reduce civilian harm in targets of opportunity is after operations happen, is how you're going to learn from what happened. So what we're seeing slowly, military is trying to do after action review, battle damage assessments, but that now are taking into account the impact on civilians and civilian objects. So there's a bit of a learning that militaries are trying to do, and we're encouraging militaries to do, that to see what are the better ways to learn from what happened during a particular incident and try to avoid making the same mistakes in the next incident. I should also just mention quickly the feasible precautions. Article 57 also talks about giving effective warnings to civilians. And again, you don't want to, I have sometimes these conversations with armed actors, they're like, oh, we don't want to tell people when we're going to launch an operation. I understand that. You don't want to, the enemy, the element of surprise is essential. But again, as part of your constant care obligation, there are ways to communicate with the civilian population, with maybe community elders, etc., that at some point in the near future, we're not going to tell you exactly that military operations are going to happen. So civilians should try to leave if possible, or try to seek shelter and safety. Sometimes civilians are prevented from leaving by the armed actor that is holding that particular territory. We've seen that particularly and very sadly in Iraq and Syria in the case of the Islamic State, which basically hides in civilian areas, uses civilians as human shields, and has prevented civilians from leaving, and when they try to leave, mows them down with snipers. That does not relieve the attacking party from taking precautionary measures, ensuring their proportionality and distinction, and taking all feasible precautions in their attack. Just because one party is violating all the norms of humanity doesn't mean that the other party does the same. And there still is an obligation to ensure that proper communication, there's warnings are being given to communities before attacks are happening, if possible, to try to create safe routes for civilians to flee. Again, I do think this is all about taking feasible precautions, constant care, and reducing incidental harm to civilians. It's all about some of the things that you can do for risk mitigation, avoidance, and I think this is a very an interesting. I would argue it should be one of the core obligations of LOAC because, and I don't know why it's just not discussed enough. So I'm a big proponent of this provision. I find it very useful to explain to armed actors that there are ways that they can take precautionary measures. So I think I should leave it at there. I'm sure there'll be lots of questions. I'm sorry, Mike.
But what's really puzzling me is how do you explain that 500,000 Iraqis were killed during the war against Iraq, not to mention what's happening in Afghanistan with tens of thousands of people are killed by the American army.
The thing about the U.S. military has made mistakes. I mean, it's very clear and it's documented. And in Afghanistan, this article that I wrote for the ICRC reviews looks at how the U.S. military and NATO forces started realizing that when in the fight against Al-Qaeda and the Taliban, civilians were getting killed. and they started developing protocols, better measures on trying to reduce harm to civilians. So the article, it spells out a little bit about some of the guidance that came from the top commanders, from all the various generals, about protecting civilians, trying to refrain from doing air attacks in residential areas unless absolutely necessary, and the highest commander to approve it, in limiting the use of certain weapons in residential areas. There was these collateral damage estimate methodologies were developed in the 2000s. Again, this is sort of new way of getting better information on fighting. And then ISAF NATO forces also started, as I mentioned, my comments, assessing how their operations were impacting civilians, and they were trying to analyze what was causing civilian harm, and then learning from it and then adjusting their tactics, providing new guidance to soldiers, providing new trainings on civilian protection. And in Afghanistan, there was a lot of documentation of numbers from the UN about how many civilians were being killed by international forces. And then once some of these measures were being implemented, there was a reduction in incidents attributed to international forces. Again, the law doesn't say zero civilian harm. The law says the obligation to reduce and minimize and mitigate civilian harm, and that military advantage should not be excessive to civilian harm. So again, the obligation is to minimize and reduce incidental harm, and unfortunately in battles there can never just be zero civilian deaths, injuries, objects. So there's a bit of some of these measures that were taken. It also depends on how they implemented, how much emphasis command puts on protection of civilians and adherence to the law of armed conflict, and sort of includes it in all phases of operations, I was saying, taking constant care. On the Iraq post-2003, I'll leave Mike to sort of address that a bit more. Laura may have.
Oh, I can address it in just the general matter. Both presentations, both last night and today, were not meant to convince you that we can conduct surgical warfare. Anyone who's been to war, anyone, there are people in this room, knows it's hugely complicated. You may have misidentifications of targets because of time of day or because of weather. You have weapons malfunctions. In the first Gulf War, we had a lot of problems with heat-seeking missiles because of the fires that had been created. We didn't anticipate that the fires would cause the missiles to skew, and the missiles would skew and go ballistic and kill civilians. And then there's lots of human error because, as you see, it's very, very complex, and it's easy to make a mistake.
My second question is about, this is for all the panelists, I don't know who's going to answer it, is about establishing civilian communities within unoccupied territories while these communities are armed, fortified, and properly trained for their mission to protect the area in which they are living. Can they be defined as a legitimate target in times of hostilities?
There was a question on the settlements and whether they become military objective or not. So I think we need to separate clearly two issues. The first one is the question of the settlements in and of themselves, and you alluded to the fact that they are problematic. In our view, as is publicly known, a state cannot have a settlement policy and encourage the transfer of his population to occupied territory. That's violate Article 49, paragraph 3 of the Fourth Geneva Convention, and we are clearly on the record for that. Now, this, if I can put it this way, is irrelevant for targeting purposes. It's a violation of the Fourth Geneva Convention, but it's not relevant for targeting purposes. For targeting purposes is only the rules on targeting. So whether the civilians who are there and who might be armed, and if hostilities start in the occupied territory, then whether they take a direct part in hostilities or not, and if the place, the building, the fortification that might have been built around are used in a manner that turn them into a military objective, then they become military objective and lawful target. And if they don't, then it's not because they are a violation of the Fourth Geneva Convention that they could become a lawful targets. That's really two completely different issues.
And now I'll invite Professor Schmidt to discuss some new ongoing research on the notion of uncertainty in targeting.
With regard to Laurent's presentation, I agree with almost everything that has been said, but I would invite you to ask me a question about continuous combat function. I'm just setting that up for the Q&A. Good morning. What I'm going to talk about this morning is about some thinking we've been doing at the War College, myself and a recent graduate of the Command and Staff College at the War College, Mike Schaus. And it all began, this thinking all began with the ICRC's work in using wide area explosives in urban areas, wide effects explosives in urban areas. And we were wondering, the work that the ICRC has been doing has raised some questions in states, and we wanted to take an objective look at their work. But in the discussion of urban warfare, what we got caught up on was the issue of uncertainty. Because if you're engaged in urban warfare, and indeed if you're engaged in any warfare because of Clausewitz's, fog of war, it's all about uncertainty. It's about, do you know that what you're shooting at is in fact a military objective, a lawful target? How do you calculate proportionality when you're not sure if there will be civilians in the area, or you're not sure of the effects of your weapon? And then what Sayer was talking about, I agree with her 112% with respect to precautions in attack. When do you have to begin to take precautions in attack if you're not certain that collateral damage will be caused? So we began to think about this. In fact, we're still thinking about this. In fact, I was on the phone with Mike just yesterday talking about this, changing the slides yet again, and I got up at 6 o'clock this morning and changed the slide one more time. So this is a work in progress. We certainly would welcome your input. We want to understand uncertainty. We begin by looking at the treaty law, which at least I believe is reflective of customary law. Not everyone agrees with that premise, but I believe what you find in the additional protocol reflects customary international law. There are two provisions that talk about doubt. The first one is Article 50. It says, listen, if you're in doubt about whether an individual is a civilian or not, then you must presume that individual is a civilian. Very simple. And then in Article 52, if you're in doubt about whether an object that's normally used for civilian purposes, like a home, like a school, like a store, is or is not a civilian object, then you presume it is a civilian object. I know that some states, including my own, question some of these, but I will tell you, I was a targeting officer, and this is always what we do. I think there's plenty of state practice, in opinion of yours, to support the customary status of this. And then there's the rule of proportionality, which you should know, and the rule of proportionality tells us if you have an attack, and that attack is expected, so there's an element of uncertainty there, expected to cause incidental loss to civilian life or damage. In other words, if it's expected to cause collateral damage, then you assess it relative to the anticipated. As Laurent said, it's not the harm that actually occurs. It's not a post factum analysis. It's what you think the military advantage that your operation is going to yield. So there's an element of uncertainty there. And in an important commentary by Botha et al., Michael Botha is a German scholar, along with a couple of other distinguished scholars, they said mere speculation is never enough to satisfy uncertainty. So we agree with that. Mike and I agree with that. So we've established mere speculation has a floor. If you're simply speculating, you're just kind of guessing on whether that's a civilian or whether this is a military objective, stop. It is a civilian. It is a civilian object. Now, here's the problem. And this is what we're struggling with. I'll use this paper here. Here's the problem. We're not sure what doubt means, okay? We're not sure what doubt means. But doubt must be something like this. Now, we can debate. Is doubt beyond a reasonable doubt? Is it a preponderance of the evidence? If you have a 70% chance that that individual is who you believe that individual to be based upon intelligence of all sorts? Is that good enough? And if 70 is good enough, is 69% not good enough? And the same thing applies in proportionality. You know, the problem with proportionality is you're trying to figure out military advantage and incidental injury. So again, you have this doubt. You're not sure where it is, okay? But if you cross this threshold into the area of certainty, then all the collateral damage counts, all of it. And if you're down here, you can't engage in your operation. Same thing with regard to military advantage. If you have enough military advantage, if it's a command and control facility, then you take the command and control facility in and of itself. You don't factor in any other consideration. And if you don't have enough certainty, then you don't. That's not what happens. That's what happens when you read the book and you don't think about it a little bit, but that's not what happens in reality. So Mike and I have been trying to figure out, how do you factor uncertainty into these three issues? Is it a military objective? Is my strike going to be proportionate? And do I have to take feasible precautions in attack? So here's what we came up with. The first, military objectives. As Laurent correctly told you, there are 5. I made a mistake on here, and as soon as he was talking, I realized that. There are 5 types of military objectives. Combatants in an international armed conflict, fighters in a non-international armed conflict, because there's no such thing as combatancy in a non-international armed conflict, individuals who are directly participating, then my mistake, organized armed groups should be up here. And finally, with respect to objects, you apply the analysis set forth in Article 52.2. Okay? These are military objectives. So what do you do with certainty in the case of military objectives? By now, you should be impressed. Pretty cool, huh? It gets better. And by the way, Mike, who is a graduate of West Point, is the guy who thought up these things, but I think they're good. And even if they're not good, they are, in fact, cool. Okay, so here's the way we think, commanders actually think in the field about, is that a military objective? They don't go, do I have 70? Do I have beyond a reasonable doubt? They don't do that. What they do is say, what's the value of the desired effect that I'm trying to achieve by attacking that individual or that object? By the way, desired effect is important for you to understand. You don't say a tank is a certain value. You look at the way the tank is being used in those circumstances. So if you have a tank which is precluding passing through a village, it may be very important if it's blocking your movement. But if you have a tank that's sitting idle in a field, that tank is less valuable than the one in the village. Why? Because you're supposed to focus on the effect of taking that tank out of action. So you're always looking for the effect of targeting the object, not the value of the object itself. And then you ask, what's the certainty? This is the symbol we're using for certainty. What's the certainty that I got it right? What's the certainty of my identification? So let's take an insurgent leader who's very important. The insurgent leader is very important. You may be told you have a 50% chance that the value of the target, you consider it in light of the certainty. So if you have an insurgent leader, maybe 50% certainty that that individual is, in fact, the leader, is good enough. We had this debate with Osama bin Laden. At one point, this certainty was 30% early on in the process. But that's Osama bin Laden. That's a really bad guy, and the desired effect is huge. That might be good enough. By contrast, if you have an insurgent fighter, you think it's an insurgent fighter, on a mountaintop, he's all alone, he's not near your troops, maybe 90% isn't good enough. Why? Because that individual is of little value. So you do this in every case. Now, proportionality, I've already mentioned it. What you're looking for here is incidental loss and concrete indirect military advantage. So let me wow you with incidental loss. Mike taught me that this symbol is the symbol for sum. I didn't know that, okay? I took math for non-math majors in college, so I'm learning a lot here. That means sum, this means add it all up. What do? You look at the value of the civilian or civilian objects, and you consider that in light of the fact, in light of the certainty that that individual will in fact be harmed as a result of your operation. Do you remember last night when I was talking about collateral damage estimate methodology and I was talking about inner annulus and outer annulus? If someone is close to the target, they count as one, but if someone is at a greater distance from the target, you don't count them as one in the collateral damage methodology. Why? Because the bomb blast, the force dissipates over distance. So in this case, that individual who is in the outer annulus is one civilian, but because they're distant, the harm, the likelihood of harm to them is diminished, so you don't count them as one. And then what you do is you look at all the collateral concerns, you add them up, and that tells you what the incidental loss is that you're going to factor into proportionality analysis. Now the other side is the incidental injury cannot be excessive relative to the military advantage. So again, we look at what we're trying to do, not at the object. We're not asking, it's a tank, it's a mortar, it's a command and control facility, or the weapon storage area. No, you're asking, if I take that out, what effect will that give me? How important is that to me in my military operations? And then you look at the certainty of achieving the effect. You factor that in, because you may not achieve that effect for a lot of reasons. So the likelihood of achieving the effect consists of a combination of, have I identified the right target? That factors in. Maybe you're looking at something and it's not in fact the right target. You've got to ask, if I conduct my operation, am I likely to actually destroy the object? Because if it's an individual in a building, maybe the building will shield, for example. So what is the likelihood for an individual that I will kill that individual, or for an object that I will damage or destroy that by virtue of my operation? The weapon I use, the weather I use, the structure of the facility, on and on and on. And then you have to add, this is what we've been talking about this week, this is what we thought about this week. You have to ask the question, okay, I'm trying to achieve a particular effect, but am I right that if I've identified the target properly, and if I know that I'm going to get my kill, okay, is it actually going to generate the effect I want? So we were talking about the insurgent leader. We often target insurgent leaders. Why? Because it will disrupt command and control. That's very valuable. But what if the insurgent leader is killed, and in fact that insurgent leader is quickly replaced by someone just as good? Well, I thought I was going to get, we were talking 6 months of disruption of the group's command and control. Maybe I got 2 weeks of disruption. So you have to ask, hey, how likely is it that my planned operation is actually, even if it's successful, even if I've got the right person, actually going to cause the desired effect? So this I don't need to explain, because this is simple. It looks complex, and you should take pictures. I encourage this. It looks complex, but it isn't. It simply says, is the incidental injury, this is our formula for incidental injury, is it excessive relative to the military advantage? And then my last one, precautions in attack. It's already been explained better than I can do by Sahir. That one's easy, and this is it. Do you have to take precautions in effect? Well, what you have to ask is, here is our formula for incidental injury. If the incidental injury is more than mere speculation, you calculate all the likely incidental injury. If it's more than mere speculation, you must take precautions in effect. Why? Because as she told you, the rule is take feasible precautions. And if they're feasible and they would alleviate harm, Why would you not take them? So it isn't an issue of how likely is it that I'm going to cause harm. If you simply aren't speculating and it's militarily feasible, do it. It's that simple. And I'll finish right on time. Thank you very much.
I just wanted to react on 2 points on Mike's very interesting presentation and the figures. In terms of assessing uncertainty for a military advantage, you are in good company, certainly with regard to assessing the value of military advantage. The prosecutor brief for the ICTY in the Gotovina trial said exactly what you suggest mathematically, but that the concrete and direct advantage anticipated is not the value of the target wholly in abstract, but rather the abstract value relative to the likelihood of, in fact, neutralizing or destroying the object. So I think that's what you make in your formula. Now, that's one point, but I think I would differentiate that from the question of doubt and the threshold issue that you mentioned, because you also use probability for the doubt or not. And to take the example that you gave of such a huge target being only 30% and whether the such importance of the target can compensate, I would certainly disagree. I think if there is only 30% certainty that this is a target, there is doubt in the mind of any reasonable commander, and here the doubt takes place. The ICTY expressed the view that it's the reasonable commander standard, and that reasonable commander needs to be convinced. Now, what does it mean? And I agree that it's not convinced beyond reasonable doubt in the sense of a criminal law decision by a judge, even if the words are very much similar, and that's, we have again a difficulty because it's a reasonable commander and it's the question whether he has doubt. But it's not the same threshold. But I don't think we can really say it's 52% or something like this.
Can I just comment on the Osama bin Laden thing, or, high value target? You don't always just have to drop a big weapon, a big bomb on that. You can do house-to-house searches, and that's what they did in the Osama bin Laden thing. So the guys went in, they didn't drop a big bomb because the likelihood of civilian harm, because it was in a residential area in Abbottabad. The same thing we're seeing in Iraq. I think the battle in Mosul, if I can digress a bit, is that, it's one of the most complicated battles in a very urban areas with hundreds and thousands of civilians. And towards the end of the last phase of the battle, a lot of the Iraqi forces were going house to house because there was a lot of airstrikes as well, but I think because there were still so many civilians that were trapped, ISIS was not letting them leave. And again, the commander has to make a decision about what is the best use of deploying force. So you don't have to always bomb houses. It's, are your forces trained to do more house to house? So that means using smaller weapons, and there could be less harm to civilians. So I think, again, these are the choices that commanders have to constantly make depending on civilian presence, density of the population, the environment, training of your forces to do to engage with the enemy, but also protect civilians.
So basically, I'm trying to make this question a little provocative, I guess. The conventional wisdom is that proportionality cannot be quantified, and I think this is more directed to Professor Schmidt. And that has implications for other fields of IHL, including autonomous weapons systems. So I'm wondering, because I see your presentation today and your presentation yesterday, they're very numerical. Could your research bear the risk, and I do want to use the word risk, that it might end up being used for autonomous weapon systems and therefore making humanitarian law more numeric and taking humans a little bit more out of the loop than it is now? Could it have those implications, or is this just a theoretical framework that would not work for a robot, for example?
With regard to the quantification of proportionality, what you must understand is that in the CDE estimation process, you still have the proportionality call to be made by the commander, and it's not quantified. all you're doing there is trying to apply a system that will minimize, it's called mitigation, minimize the harm to civilians and assess the number of civilians that are likely to be harmed by your strike. But that still leaves the proportionality calculation in the hands of the commander, and so you're not really quantifying. What we're doing, what Mike and I are doing with our research is not trying to determine exactly what the numerical factor is with regard to factoring uncertainty, but trying to understand how people actually think about it. And I think it's important to understand how commanders think about uncertainty in the field, because there is this misconception that it's sort of this either-or thing. It's either proportionate or it's not. What we're saying is it depends, that each case must be assessed on its own merits. Now, autonomous weapons, oh my God. So, you know that there is this effort to ban autonomous weapons, Stop Killer Robots, a very clever title, but a lot of that discussion dramatically misunderstands the law and misunderstands autonomous systems and is thinking of AI systems that are well into the future. It's an emotive debate that's devoid of much legal discussion. I've written on this, you can read my piece. I personally believe it would be possible to have an autonomous system that that engages targets consistent with the rule of proportionality. And the way that's done is, what you must remember is the commander decides to put that system into the battle space. So the commander who's using the system, just like a commander who launches a Tomahawk missile or a fighter pilot who drops a JDAM, decides in the circumstances at the time, can this particular weapon system be used in a manner that is proportionate? And in fact, it's been suggested, for example, that you could have systems that would, we already know that an autonomous system can identify people, can determine what objects are, can distinguish a tank from a truck. It can do all this with current technology. So there is speculation that you may have a dial, a collateral damage function on it. So if you're going to employ that system where there are civilians, maybe you dial down the appropriate kill factor and so forth. There is a problem with proportionality, though, in autonomous systems, and this is what I wrote about. The problem with proportionality is not the system being used in particular circumstances determined by the commander. It's about putting that system out there, and over time and space, the determination to engage by the autonomous system will be less and less reliable with regard to proportionality. Why? Because everyone that's been to war knows the situation out there changes quickly. You have transparency of what's in front of you, and the further you move out this way, your understanding of the battle space diminishes. And the same is true in time, because people pass through and so forth. So using an autonomous system discreetly, I think, is possible in certain circumstances, but I believe that such systems should be tethered so that the commander can override the system if the circumstances changed, or I believe the systems should be limited in terms of time they're in the battle space and distance they cover.
This question is directed for Mike Schmidt. I saw the formula, and that was it was pretty cool, but the question I had was, how do you determine what the values are specifically? So let's say, for example, the value of an adult male as opposed to a child or a female. Who would make that decision, and is that constantly changing? Or and to piggyback on that, the CNN effect, do you account for some value in there in the calculation?
I know the question was directed to Mike, but as I have the floor, in terms of the value, I think the value of a civilian life, it's that it's a life. And it doesn't matter whether it's a female or a male or a child or anything, that's a life. And a life is a life, and you would count them the same. Now, that only partly answers the question, because then you still have to, in a way, balance that against the military objective, so give them a value. But if your question was, do you differentiate between different values in terms of civilian life, I would not.
The CNN effect, wow, that's a cool question. I don't know that I know the answer to that. We're not thinking about that. So maybe we could talk later. I mean, that's the great thing about coming to places like this. It never crossed our minds.
There are around 10 army people there in the bus and 40 civilians. But they thought that they are traveling in a bus, and if they enter in the village, the army people will kill all the insurgents because they have equipped arms and ammunition. As insurgents do not have such arms and ammunition, only they have traditional weapons. That would not be sufficient for them to fight against that arms. They blast the bus.
Okay, so soldiers are traveling with munitions in a public bus.
Yeah, public bus.
Well, there's also an obligation for armed actors not to unnecessarily expose civilians by traveling with them in the same vehicle or having their munitions in the same. But at the same time, the attacking party needs to know more and should be able to assess who's in the bus and if therefore, 5 soldiers, 40 civilians. Again, the attacking party has a responsibility also to know more. I don't know, if you have 40 people in the civilians in a bus and 10 soldiers, I think it's pretty clear that that's problematic to continue with the attack. I mean, it's better to wait till maybe they'll arrive, the passengers are let off, and then engage in an attack. Again, feasible precautionary measures, it's about refrain, canceling attack when you know there's so many civilians present, and how much information you can get and see. And there's, of course, the proportionality argument as well. And I lead Laura and Mike to address that. Anybody?
There is a proportionality question, but I would still focus on the precautions and whether the attack could have been done differently. Could you not have blocked the bus instead of blowing up the bus? And you would have the same direct advantage that then the soldiers cannot reach the village. If that was the main concern, that the soldiers don't kill the insurgents in the village. That's the purpose of the insurgents. You just blow the road in front of the bus, and depending on how is the path to go, then the bus is blocked. So you might have lots of information on the circumstances and thinking in a way creatively to see whether you could have done that operation differently. Then in terms of proportionality, I think that's pretty concerning if you would do that anyway.
I'll be a little more definitive than my friends here. I think it is a violation and it's a war crime. Because unless you're talking about 5 generals, I don't think any reasonable commander, a reasonable warfighter would ever conclude that killing that many civilians in order to kill 5 individuals would be proportionate. So I believe that there's no question that that's a war crime. But I would also emphasize all of the precautions thing. I agree completely on all the precautions comments.
I don't have any military background, I don't have targeting experience, but if I'm teaching IHL, I will deal with targeting and conduct of hostilities. And what I'm struggling with is not to give just to repeat what is in the book. That is probably the risk I have, to just explain maybe in more simple terms what is in Article 57. So what would be your suggestion to try to explain to students the targeting rules and the conduct of hostilities in a way that is more adherent to reality?
A few things from my side. I think this new initiative is IHL in Action, looking at success stories that the ICRC is collecting. I think it's going to be a very useful resource for teaching. I think there are a lot of military manuals and guidance that are public that professors should review to see how militaries actually translate law into practice. And then also I think it's useful with real life examples. I think a lot of NGOs and UN Commission of Inquiries and organizations who are doing assessments of civilian harm, they put out reports with actual fact patterns. And again, it's useful to look at those fact patterns and see what is the approach and application of law. And I think using real life examples would make the teaching more successful.
I think it's a responsibility of a professor and instructor to reach out to the military. If they're going to be teaching military matters, they should reach out to the military. What they'll find is the military will welcome them in terms of explaining what it is they do. There are professors who have participated in military exercises, for example. I also think it's important that they join the associations that deal with military affairs. The premier one in this field is the International Society for Military Law and the Law of War. They can join that association where they'll interact with judge advocates on a very regular basis. And finally, at West Point, there is a new program that that brings people in from academia, from the NGOs, from the ICRC, to have them spend a week or two focusing on how military operations work, and I think that would be very valuable.
I agree with what both Mike and Sarah just said. The practical and very multidisciplinary approach is very important for the teaching and discussing with the military, and the other way around, also inviting militaries to possibly participate in the course. And additional resources beyond everything that you mentioned, Sarah, is the online casebook on how does the law protect in armed conflict, and that we have published, and which gathers precisely many of those material in a manner which is already hopefully useful for professors. It's important, especially for the application of the rule of IHL, to remain very practical and understand how conflicts are fought and how decisions are made by people on the ground in the middle of the operation.
Yeah, I would just echo that. I think that giving real-life examples of the measures you can take in terms of applying proportionality, distinction, feasible precautions is key, so there's a better understanding of how law is applied in practice.
And what I took away is that it's very important that the various communities that are involved in IHL work together. The ICRC, the NGO community, the military community. I don't think any one of the three has necessarily the right answer, but working together, I think we can really advance the application of law on the battlefield.
Thank you to the three of you again.